Hello, my dear students. I am here with the amendments for CMA Final Law for your upcoming examination, that is June examination going to be held in July 2023. Now, बड़ा confusion है. Solid confusion exists amongst the students with respect to amendments and ये जो supplementary है which I have currently with me, and institute has actually released a supplementary saying for new syllabus, for old syllabus, and it's a combined supplementary for CMA inter and CMA final students, is a complete mess. Please don't fall for it. My simple request to you, please don't even look at this supplementary. It is going to lead you nowhere, absolutely nowhere. This is the terrible supplementary I've ever seen. इसमें इतनी 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 गलतियां हैं भर भर के कि मैं आपको क्या बताऊं. ठीक है, तो सबसे पहली बात, यू डोंट हैव टू लुक एट दिस पर्टिकुलर सप्लीमेंट्री. इट इज अ ह्यूज पूरी पूरी लिस्ट ऑफ सेक्शंस दे दिए, वेदर इट इज इन आवर सिलेबस, वेदर इट्स नॉट इन आवर सिलेबस, दे डोंट इवन केयर. दे हैव इनकॉर्पोरेटेड एवरीथिंग, राइट. एंड देयर आर अ लॉट ऑफ मिस्टेक्स लाइक दिस ऑल्सो. भाई वो सेक्शन कोई है, उसमें कोई अमेंडमेंट ही नहीं है, सालों साल से कोई अमेंडमेंट नहीं है, फिर भी कुछ लिखा हुआ है. सो देयर आर अ लॉट ऑफ मिस्टेक्स. आप शायद देख के इसको बहुत ज़्यादा कंफ्यूज हो जाओगे. सो आई इंसिस्ट यू दैट don't go for the supplementary. Now the question is, see, there are so many sections which are not even in your syllabus, my dear, right? But they have just released a huge set of list and they have just told you, okay, fine, there is this particular thing which has been added, maybe this particular thing which has been amended, maybe, and that is also a maybe, because that is also not 100% correct information that they are giving, right? So, and new syllabus, old syllabus, there's no differentiation between the two. They have just released two files. They're almost the same. Okay, so my request to you all once again is that don't look at this particular supplementary. Now, ma'am, how do we cover the amendments of CMA Final as well as CMA Inter? This particular video is for CMA Final students 2016 and 2022 syllabus. Both I'll be covering. Now, all the students who have taken classes from me, that is my registered students, you have to cover hardly any amendment, right? Because almost all the amendments have been incorporated in the classes, because as I take the classes, whatever new comes, I try to incorporate therein itself, right? But of course, when I am uploading something on YouTube, I have a responsibility towards my YouTube family as well. So all the students who are not my registered students, for them also I have tried and beautifully designed an amendment sheet. Okay, so this is an amendment PDF that you can definitely obtain from my Telegram channel. You'll find the link in description. Now you can see, ma'am, there is a huge list of amendments. Oh my God, there are so many amendments. No, my dear, there is hardly any amendment for you. But what I have done is, because the institute's material is old, right? Institute has in its supplementary included a lot of old amendments also. And there are many students who are not even aware of any updation which has come even a year back or maybe 2 years back, right? So what I have done is, see, as you can see the heading over here, important old amendments for self-reference. So I'm not going to tell you these amendments in the class, because of course they are very old amendments which have already been covered, which have already been incorporated, yet students are not aware of the same. So these are the amendments that you can just quickly review, that your knowledge should be updated. Okay, as in the definition of listed company. So we have a new rule which has been inserted, which actually excludes certain categories of companies from being classified as a listed company under Companies Act 2013, right? We have a good amount of amendment in the concept of OPC. While I was taking live sessions, I realized that many students don't even know the same OPC changes which have been incorporated long back, right? So likewise, we have certain amendments that I have incorporated in the chapter of directors, for nidhis also, but nidhis is applicable for 2016 syllabus only, and so is SEBI loader applicable for 2016 syllabus only. So I've specified on top, right? So you can look at certain amendments which are old for your self reference only. Now, Coming back to the new amendments, even in new amendments, there is a major addition to your syllabus, which is PPIRP. Pre-packaged insolvency resolution process, which is a new chapter added to the chapter of insolvency and bankruptcy code. Earlier, it is also not a new amendment. Let me be very clear. It is something which was added or which came as an amendment around an year back, but it was not notified to be a part of our syllabus. Okay, now since it is incorporated in supplementary, see, I have put a lot of efforts. I have analyzed the supplementary, and thereafter, after analyzing the supplementary and making this file for you, I am here with the amendments. So it took me quite some time, but I'm here with a solution for you. So since that has been notified, now you have to read PPIRP also along with IBC as a part of your syllabus. So ma'am, where will we get PPIRP? I have incorporated it in the same class. So after this amendment, you will have another video added to this, which is PPIRP. Okay, pre-packaged insolvency resolution process. I insist everyone, if you do not remember IBC, it might be a little difficult for you to recall PPIRP, although I have explained everything in detail. Yet there is another revision video of IBC which is uploaded on the channel. So in case you've forgotten the concepts of IBC, quickly brush up with the revision lecture, and thereafter you check this amendment of PPIRP. Okay. Now, coming to the leftover amendments. Now, if you see, it is hardly a matter of 15 minutes and all your amendments will be done. So it's not going to take much time unless you actually know what you have read. Okay, so amendments are always post-learning. It cannot be pre-learning. Right, so once you have learned the concepts, and then if you come and do the amendments, it is going to be very easy and very quick for you. Right? So amendment video is not going anywhere. If you have not read the entire syllabus, I insist that you read the syllabus as you are reading, and thereafter you can check the amendments and incorporate the same in the material that you're using for your studies. Okay, so let's begin. I will also make you mark, there are certain amendments which are considered to be important ones. So I will make you mark that also, and accordingly you can study, right? Okay, so in the very first chapter, company formation and conversion, we have a very important amendment, I would say, which is in the definition of small companies. The 5th September, I believe, 2022, this limit was changed. See, we all know section 2 clause 85 defines what a small company is, which means whose paid up capital does not exceed 50 lakh or such higher sum as may be prescribed. Now, this higher sum prescribed was 2 crores for paid up capital and 20 crores for turnover. This has again been changed. Earlier, there was nothing prescribed. So we considered the limit of 50 lakh 2 crores. Now, after that, there was limit prescribed, a higher limit prescribed, which is 2 crores and 20 crores. And thereafter, a new limit has been prescribed, which is 4 crores and 40 crores for paid up capital and turnover respectively. This is an amendment class, so undoubtedly I'm not going to explain you the entire concept of small company. If you want to brush up your concepts, you can refer to the marathon for the same. I hope this makes everything clear. So 4 crore and 40 crore for paid up capital and turnover respectively. That is the new limit which you have to remember. Coming to the chapter of accounts and audit, you have an amendment in section 128 and thereafter few amendments in CSR. Now CSR entirely you don't read in this particular chapter. You also read in the topic of corporate governance. And when I'm talking about the new syllabus students, they read a lot of things in the chapter of corporate governance. So CSR is more a part of corporate governance than a part of this particular chapter. However, I've incorporated it over here only because we derive these concepts, we derive these provisions from Companies Act section 135 and relevant rules only. Section 128. The books of accounts and other relevant books and papers maintained in electronic mode shall remain accessible in India at all times. So what has been added is highlighted in red. whenever a company, see, it is mandatory for every company to maintain books of accounts, and whenever you maintain books of accounts, you're also permitted to maintain books of accounts in electronic mode. But if you maintain books of accounts in electronic mode, there is a rule 3 which gives you a list of things which you must comply with, and thereafter only you can maintain books in electronic mode. So it has to be accessible in India at all times. At all times. The backup, if the server is, the server has to be physically located in India. So backup, if any, shall be kept in that server. There can be an outside server. So if the server is outside India, the backup shall be taken and it will be kept in server which is physically located in India, and that is going to be done on daily basis. And one more thing, if your service provider is located outside India, the name and address of the person who is in control of books and papers in India, that has to be furnished with ROC. Okay. So this is not an important amendment. This is a very important amendment. And now coming to the chapter of accounts and audit, what becomes the important amendment is not really much. This particular one is more important compared to the other two. What is it, ma'am? First thing, you all should remember that previously we have witnessed a lot of amendments in section number 135, that is the concept of CSR, for example, and they are also very important amendments. So even if you go to the old amendments and you look at these amendments of CSR, they are very, very, very important. Like what, ma'am? Like this set off, like this amount unspent with respect to ongoing project, and this one. See, we have section 135 which tells us if you satisfy these three criteria, any of these, then you have to form a CSR committee and incur CSR expenditure. However, we have a subsection 9 which states that if your CSR expenditure is less than equal to 50 lakh, then there is no requirement of CSR committee. However, you must go for CSR expenditure. CSR expenditure is mandatory. CSR committee formation is not mandatory. Then who will do the CSR expenditure? See, CSR expenditure is ultimately done by the board of directors only. It's just that CSR committee, if formed, recommends it to the board. So now the board does not need any recommendation. The board itself will take up whatever they think and feel is correct for the company. Okay. So no CSR committee is required if the expenditure does not exceed 50 lakhs. Clear? So this is an old amendment which is important. So I've just made you recall it once more. Now, we also have been introduced the concept of unspent CSR account. Unspent CSR account is for ongoing project. Okay, because many a times it happens that, okay, I want to do something really good for the society, but then it cannot be done in 1 year. And all my compliances are being checked in a span of 1 year. Oh, in this financial year, you had to spend 1 crore for CSR. You did not spend it. You spend only 50 lakhs. Maybe in the next year, I'll spend 1 crore 50 lakhs. So if my project is of 2 years, maybe in 1 year, I can spend just 10 lakhs. And in the next year, I can spend more than what is required in CSR. So balanced, it has to be checked cumulatively, collectively. And for that, we have unspent CSR account which is being opened with the scheduled bank, and thereafter supposedly your CSR expenditure, minimum CSR expenditure for a financial year is 1 crore, and you could spend only 10 lakhs in an ongoing project, then remaining 90 lakhs will be sent to unspent CSR account. Right? Now, although we don't need CSR committee if our CSR expenditure does not exceed 50 lakh, but if anyone has unspent, if a company having any amount in its unspent CSR account, it shall constitute a CSR committee. So in this case, you are required to constitute CSR committee. Fine. Now, earlier it was there that, okay, fine, if you cease to fulfill that criteria, you are no longer required to form a CSR committee. Now that rule has been omitted. So now no relaxation is given to companies to not form a CSR committee if they no longer satisfy the required criteria. There is another rule 8 which is often confused by the students with rule 7. My dear, rule 7 also has a percentage given. Rule 7, ma'am, do we need to learn these rules? Do we have these rules in our syllabus? Well, whatever I'm telling you is a very well thoughtful, studied, analyzed things for my CMA final students. So don't have a second thought or a doubt whether I need to read this or not. If it is asked in examination, don't come and say, ma'am, this was not given in the material. How was it asked in examination? Well, it can be asked in examination. That is why I'm telling you this, right? Okay. Now, Rule 7, administrative overheads. We talk about CSR expenditure, right? So we talk about administrative overheads which cannot exceed 5%, right? Whatever is the part of administrative overheads. Now, this is something else. This is about impact assessment. Impact assessment is not mandatory in all cases. It is mandatory where your project exceeds a certain threshold, right? So in that case, this is more relevant for the new syllabus students, for 2022 syllabus students. This is more relevant for you. So if amount spent for impact assessment that you can consider as CSR earlier, it should not exceed lower of 5% of the total CSR or 50 lakhs. Now it has been reduced to 2% only. So higher of 2% or 50 lakhs. Supposedly 2% comes out to be 1 crore. So 1 crore. 1 crore you can spend for impact assessment and that will be considered as a part of CSR. Okay. Again, let me tell you, if you intend to think that, okay, I am going to explain you impact assessment over here, no, my dear, it is an amendment class only, right? Moving to next part. See, when we do the filings, we have to do an additional filing, which is filing CSR 2. Now, since it has been recently incorporated, the dates keep on extending. So, CSR 2 for financial year 2021 was earlier required to be filed on or before 31st May 2022. It is now required to be filed on or before 31st March 2023. So, this is again not relevant. Fine. So what is relevant is, this is very important. This I have marked as important, and now we move further. So only 2 amendments so far I have marked as important. Right. Moving to the next part, that is the chapter of directors. Okay. In the chapter of directors, I hope you all remember something called as independent director. Independent director, we have a data bank which is being maintained, and anyone who intends to become independent director has to apply accordingly, get your name in that data bank, and thereafter independent director may be appointed, right? There are certain people who are exempted from appearing for that aspect, right? I'm again taking you to the old amendments. See, here it is. Right. See, exemption in online proficiency self-assessment test, right? Here also it is exemption, here also it is exemption, right? So you know that there are certain category of people who are exempted from appearing for this particular test. Otherwise, you have to appear for this particular test, and thereafter only your name will be included in this data bank and you can be appointed as an independent director. These are old amendments I'm not discussing, but coming back over here, if at all you do not appear or you do not pass this test, that is online proficiency self-assessment test, if you do not pass, then your name is removed and you do not have any opportunity of restoration of name. What you have to do is make a fresh application for again inclusion of your name, right? But now this has been introduced. You have a procedure for restoration of name in data bank if it is removed on non-clearance of exam or non-appearance of exam. So any individual whose name has been removed from the data bank may apply for restoration on payment of fees of 1000 rupees, and the institute shall allow restoration subject to your name is shown in a separate restored category for 1 year. So once restoration is done, straight away your name will not be in the main list. It will be in a secondary list. That is, it will be for 1 year. It will be in a separate restored category, right? And within that 1 year, you will be required to pass OPSAT, right? And thereafter, your name will be included only if you pass it. And in that case, whatever fees you have paid initially for registration of your name, that shall be adjusted. But if you fail to comply with the same, then after 1 year, your name will be removed and you will have to make a fresh application for inclusion of your name. Clear? Not very important one. Now we come to another proviso which has been inserted, and which my new syllabus students will definitely know this amendment, more importantly because I've explained them this things in the chapter of FEMA also. What is it, ma'am? In case the person seeking appointment is a national of a country which shares land border with India, necessary security clearance from MHA, Government of India, shall also be attached along with the consent. If you want to be the subscriber, we have a company, listen to me very carefully. We have a company which is incorporated in India. Now, in this particular company, you may have a foreign subscriber. First thing, you may have a foreign investor thereafter who is purchasing the shares not as a subscriber but later on during the lifetime of the company. You may have somebody who is involved in the management of the company, that means a foreign director, right? So foreign director, foreign subscriber, foreign investor may be there. Now government is taking strict actions and government wants to regulate anyone for hostile takeovers, rather I would say anyone or any country which is sharing land border with India. So if there is a country which is sharing land border in India, their residents, they should not have unregulated management or control over our companies. They should not have unregulated control or unregulated voting power in our companies. So that's why government is taking a lot of steps. Since here we are talking about the directors, we will strictly talk about directors. So if you are a person, or a national of a country which has land border in India, then you need to obtain necessary ministry clearance and thereafter only you can be appointed as a director. So if you want to be appointed as a director, you have to attach along with your consent. Consent of director is attached, right? So along with that consent, you also need the security clearance. Likewise, if you have to apply for DIN, along with that application of DIN, you also have to give that security clearance. So both these provisos are related to that only. So you will see a lot of amendments under Companies Act due to this point or this thought of government. Moving to the next part, IBC. Again, let me tell you, after this, you will straight away have PPIRP. But before that, also you have certain things. So I am going to discuss that. Very small, not so relevant points. Section 7. There is something which has been added, which is highlighted in red. So applicant, you are going to serve a copy of application to to registered office of the corporate debtor and to the board also by registered post. See, CIRP by financial creditor, that means corporate insolvency resolution process application is moving from financial creditor to NCLT. You also have to serve a copy to your company, that is the corporate debtor registered office, and to IBBI, that is the board. How are you going to send it? By registered post, speed post, hand, or electronic means before you file the same to adjudicating authority, that is NCLT. Okay, so what is important is not just the red thing but the whole entire content, that before you file this application with adjudicating authority, this is important. Okay, before you file this application with adjudicating authority, you will also serve an application to the company as well as to the board. So copy of application shall be sent. Now when we talk about PPIRP, that is pre-packaged insolvency resolution process, let me give you clarification once again. My registered students 2016 syllabus, I've already taught you this, so you don't need to cover this as well. For 2022 syllabus, since it was not notified in your syllabus, we did not incorporate it because it was a new material, but now I insist you to read it, so please cover this. Okay, now, and for other students, of course, if you have read it, no need to cover it. If you haven't read it, please cover the same. In case you have any other clarification, feel free to ask me. Right? Wish you all the very best. So we all know about Insolvency and Bankruptcy Code, and you also know that after this IBC has been incorporated, all the insolvency laws have been done away with, and this IBC provides us a beautiful, a time-bound mechanism for reviving the firms, reviving the companies, reviving the corporates which need to, and closing down the corporates which of course are of no use. See, it happens a lot of times that maybe this COVID-19 pandemic, the business of almost, I would say, 70% people declined. And because of that, maybe the company is unable to pay its loan, is unable to repay its loan. And because of that, the banks are sending notices to the company is not making any profit so as to repay the loan. And what do you think should happen to that particular company? Should it be closed because it's unable to repay its debts? No, it must be revived, because once the situation is over, it has the potential to gain back, to rebound, to touch the heights of business, right? To touch the heights of turnover or whatever the case may be, right? So we must give such type of companies a chance. You agree with me? Ma'am, IBC is already providing such chance, because IBC's main focus is to resolve the insolvency rather than to shut down or liquidate the companies. So the first aim is to resolve that state of insolvency. We all know about the terms insolvency. We all know about the terms of bankruptcy and everything, right? And we even know that the whole IBC is divided into different parts. Part 2 being the insolvency, or being the content or provisions containing insolvency related to corporate persons. So in part 2, there are different chapters. After chapter number 3, there is an additional chapter which has been introduced. It is chapter 3A, which talks about pre-packaged, PPIRP, pre-packaged insolvency resolution process. Now, what do we mean by PPIRP? Pre-packaged. That is the concept which you need to understand. Because if we already had a beautiful insolvency regime, a beautiful mechanism, appointment, moratorium, public announcement, COC, a lot of things, when we already had this process, why are we introducing a new concept? As you can see, this is also an insolvency resolution process. We already had an insolvency resolution process. Why is the need of another insolvency resolution process? This particular process is not applicable to all the corporates. It is only applicable to MSMEs. It is only applicable to MSMEs. I have included the definition also over here. You will get this chart, you will get the notes, you will get everything, and If you're not my registered student, then also you can get the same. Please contact my team, and they'll tell you or guide you the way you can obtain these particular notes, right? Along with the charts as well as the notes. Now, what is MSME? Some students have this misconception that MSME is something else. No, my dear, MSME is a company. We are just talking general broad terms. We are talking that if a company is unable to repay its debts, maybe it's operational debt, maybe it's financial debt, then that particular company we treat as a corporate debtor, right? So such corporate debtor can be MSME also. That means it can be a micro enterprise, it can be a small enterprise, it can be a medium enterprise if it satisfies this condition. Earlier the conditions were different, now the conditions are different. The criteria is different. If you go by this criteria, almost 70% of the companies in India will fall under MSME. And these MSMEs are the ones who are building up the nation by contributing so much to GDP. So we cannot afford to lose these MSMEs just because they are unable to pay some debt, right? And this whole CIRP process, this is Corporate Insolvency Resolution process, which we have already studied in IBC, it takes a lot of time. Ma'am, do you mean to say that this PPIRP process is going to take less time? Well, yes. PPIRP and CIRP, these are the two processes that we are going to witness, that we are going to see for corporate persons. Okay. That means PPIRP is also for corporate and CIRP is also for corporate. CIRP is for all types of companies. PPIRP is only available if you fall under the criteria of MSME. So if you are MSME, then you have a choice. You can go for PPIRP, you can go for CIRP. Now, what additional benefit does PPIRP give us so as to attract this particular process? Well, I have made a chart of difference also, the difference between CIRP and PPIRP in the most simplified manner possible. Okay, so we will come to this and we will get a 100% clarity, I would say, if you listen to me very carefully. But one by one we are going to proceed. First of all, this amendment came through an ordinance firstly, and then it was adapted. It was this amendment is, I hope you know the difference between ordinance and an amendment act. Ordinance is passed when the parliament is not in session. Well, I will not start to tell you about ordinance, but I think I have posted a video for the same. You can check out what do you mean by ordinance from that, and you must know it. Now, it is introducing alternate insolvency resolution process for MSME. One thing you must note, it is an alternate. It is not the only choice that MSMEs are going to have now. It is an additional choice that MSMEs will have now. It is called as pre-packaged insolvency resolution process. Now, why is it called as pre-packaged? That also we will discuss. A new chapter has been inserted, chapter 3A, which contains sections starting from section 54A to section 54P. So all these sections are newly inserted ones, because you already know that there must be an existing section number 54, existing chapter 3. So I think I have told you this before also. Whenever through amendments new sections have to come into a picture, and they cannot be added at the end, right? They have to be added somewhere in the mid so as to keep up the flow. So after chapter 3, after chapter 3, this needed to be added. So there is this amended chapter 3A. Likewise, you have these sections. The first question that comes into mind, ma'am, what is MSME? What do you mean by MSME? We have an act which gives us the criteria of classification of MSME, although this you don't have to learn from examination perspective, but once you know this, then only you will be able to understand the whole process, right? So that's why I have incorporated this over here. There are two conditions and both have to be satisfied to fall under this particular category. Investment in plant and machinery and annual turnover. Supposedly there is a company which has invested 50 lakhs in plant and machinery and its annual turnover is 40 crores. It will be classified as a small company, because to be a micro enterprise, its turnover also has to be 5 crore or lesser along with the investment in plant and machinery. I hope you understood this, right? Both the conditions have to be satisfied. If you have to be classified as a micro enterprise, see, MSMEs have different exemptions, they have different benefits under different acts. We are talking about IBC right now. So if you fall under the category of MSME and such MSME becomes a defaulter, such MSME is unable to repay its debt, then it has an insolvency resolution mechanism called as PPIRP available under IBC. What is it? How to go for it? Everything we are going to read in this particular chapter, chapter 3A. A new chapter which has been introduced in IBC, which contains section 54A to 54P. Along with it, we also have its rules, we also have the regulations, but you don't have to read much from the rules and regulations. Okay, all that you need to know and all that is included in your syllabus is incorporated over here. Okay, we will not go in depth relating to the section, to the form numbers or to the specific procedure, because that is something that will only add on to your burden, because I know you have a lot to study right now. Okay, so I have not included all those things just to keep you focused. Okay, so this is the criteria. Not more than 1 crore and not more than 5 crore, micro enterprise, small enterprise, not more than 10 crores and not more than 50 crores. Medium, not more than 50 crores and not more than 250 crores. So supposedly if I say there is some company whose turnover is 300 crores and it has made an investment of only 10 crores. What is it? It is not micro, not small and not medium. So it is something which does not fulfill the criteria of MSME, and hence the option of PPIRP is not available to such company even if such company incurs any default. I hope it is clear. Okay. So pre-pack is an alternative to CIRP which is available only for MSME. Okay, meaning of pre-pack a little later, but before that we have to discuss about the differences. The very first thing, default amount. Now this also creates a lot of confusion in students' mind. If the default, supposedly I am a company which fulfills the criteria of being a micro enterprise. So I am a company classified as a micro enterprise. Okay. I have taken a loan from bank. Supposedly the amount of loan is 5 crores. Now I am unable to repay the loan. I become the corporate debtor and that bank becomes the financial creditor. If that financial creditor is unable to recover money from me, the financial creditor has a choice. It can go and file an application for my insolvency resolution process, right, under CIRP. It can go for corporate insolvency resolution process because section 7, 9, 10, you know that operational creditors can file an application, financial creditors can file an application, even the corporate debtor itself can file an application for insolvency resolution under CIRP. That is the normal corporate insolvency resolution process that we have studied so far. You agree with me? Now, I have not paid the amount of 5 crores. I have not paid the amount of 5 crores. I am MSME. That particular bank is my financial creditor. Can I go for PPIRP? Now the students get confused over here. They see that the default amount is 10 lakhs and here the default amount is 1 crore. So if the default amount is more than 1 crore, then I have to go for CIRP. This is the confusion. This is not correct. This is the confusion that students have over here. So I would write minimum default amount. See, earlier it was 1 lakh. It has been changed to 1 crore. So the minimum default amount, if you want to give an application for resolving the insolvency of any corporate debtor, the minimum amount of default under CIRP is 1 crore. The minimum amount of default under PPIRP is 10 lakhs, my dear. There is no limit on maximum amount of default. That means even if this MSME is unable to repay that debt of 5 crores, it can still go for PPIRP. It can still go for PPIRP. So we get the minimum default amount, we don't get the maximum default amount. You get my point? Now such MSME has a choice. Such MSME has a choice. I can go for CIRP also. I can go for PPIRP. So, but listen to me very carefully, very carefully. The bank wants to, that financial creditor wants to resolve my insolvency. That financial creditor cannot file an application for PPIRP. I repeat, that financial creditor cannot file an application for PPIRP. The option to file an application, the power to file an application under PPIRP is available only and only with the corporate debtor. Under CIRP, financial creditor can file an application, operational creditor can file an application, and even the corporate debtor itself, that is the corporate applicant, can file the application. But under PPIRP, only the corporate debtor can file the application. That means if financial creditor wants to resolve my insolvency, it has no choice but to file an application under CIRP. It cannot file an application under PPIRP. Okay, you get my point? Ma'am, this is kind of injustice. Well, you won't understand it as injustice once you read the whole PPIRP. Because PPIRP, pre-packaged insolvency resolution, it is informal, my dear. The bank will come to me and the bank will say, see, you are unable to repay your debts. We understand there is no dispute between us. You are unable to repay the debts. The bank is saying to the company, you are unable to repay the debts. Now, since you are unable to repay the debts, we must find a solution. The company is also eager to revive its situation. The company and the creditors are discussing what should we do. What should we do? We can go for PPIRP. Do you have a plan, a concrete plan, any suggestion that this is the way we can revive? Well, yes. So they discuss, they make plans, and with the consent of both the people, application is filed for PPIRP. It is not just the consent of this corporate debtor that you can go ahead and file an application for PPIRP. Okay. There's the consent of the financial creditor also, as well as the corporate debtor, that you come to a consensus that yes, company must attempt to resolve its state of insolvency, and for that it's better that we go for PPIRP, since it is going to take less time, it is going to be more friendly, it is going to be, there are a lot of benefits. So we must go for PPIRP and then you file an application, but the power to file an application shall rest only with the corporate debtor and not with the financial creditor. Do you get my point? Okay. Now, applicability. It is applicable for all corporates, and this is only for MSME. Who can make an application for CIRP? The corporate applicant as well as the creditors, that means the financial creditors, operational creditors. We have read the respective sections. Under PPIRP, application can be made only by the corporate applicant. The time limit, you know, is if it's including extension, it's 330 days. Here, the time limit is significantly lesser. It's just 120 days. It's just 120 days. So within 120 days, it's going to be done. Now, the default amount, minimum default amount that we have discussed now. One of the most important differences, that we have is under CIRP, the directors, the promoters, they have to take a back seat. Who comes into picture? It's the RP who comes into picture, manages everything. But under PPIRP, the management stays with the promoters as well as the director. And that is why it takes less time. That is why it is more convenient. That is why it is more friendly also. See, if I have to hand over my company's management to someone else, I might not be willing to discuss things. I might not, and the other person will take a lot of time to adjust to the atmosphere, adjust to the facts, adjust to everything. You realize that supposedly you have a person who is very dynamic and becomes the principal of a school. Very dynamic, extremely dynamic person. He will still take some time to adjust into the atmosphere, and supposedly that is the time is the main constraint over here. It took that person 3 months to adjust into the atmosphere. The 3 months expired, 90 days. But here under PPIRP, there is no shift of management. The ones who are managing the company, they continue to manage the company. Of course, there shouldn't be any fraud, any mismanagement and like things, but they continue to manage the company. So when they are continuing to manage the company, they know the pros and cons, the strengths and weaknesses. They know how to handle the employees. They know the atmosphere. They know who can work overtime, who cannot work overtime. Right? So they know everything. They know who are the dealers who will give immediate supply of goods, etc., etc. So if we do not change the management, it becomes easier and faster. So here under PPIRP, the management does not change. The time limit is reduced. The default amount, minimum default amount is less, because we are talking about MSMEs, right? And the arrangement thus is informal as well as formal. See, what happens in CIRP? Any financial creditor would make an application. Any financial creditor will make an application, and once the application is approved, then the whole process starts. So before approval of application, there is nothing. But now try to understand PPIRP process. Under PPIRP, the default occurs, the financial creditors and the management, the members, they all are going to meet. First of all, they resolve that, okay, we are going to go for PPIRP. They will prepare a plan. There will be informal discussions. What should be done? Who do you think should come and resolve this particular problem? So they suggest some name of RP, resolution professional. They approve some name. We have a plan already ready for resolution. So we have a base resolution plan which is ready before filing of application. So there are a lot of efforts which take place, a lot of informal meetings, a lot of informal arrangements, discussions, deliberations, which take place before filing of application. So a lot of informal arrangement also. And then after the application is filed, the whole process starts. So we have that set of formal arrangement also, right? I hope you have understood so far. Now, these were the differences. Of course, there will be similarities. What are the similarities? There will be some person who will be appointed as a resolution professional who will undertake this whole process. There will be a plan which is going to conform to the standards mentioned under section 30. Your plan should conform to all the requirements. So there will be a plan. The plan will be submitted to adjudicating authority. Adjudicating authority is going to approve the plan, and thereafter it will be executed. So everything will go on like that only. Once your plan is approved, there will be declaration of moratorium. So there is going to be a moratorium period. There will be a public announcement of the same, appointment of RP, that will be treated as insolvency resolution commencement date. I hope you are able to recall all that, or you are sleepy. Well, it happens that once at the time when we are studying a particular chapter, everything retains in our mind, but if we don't do constant revisions, after 10 days, 15 days, 1 month, 2 months, everything goes out of your head and it's like an absolutely new subject, right? It looks like, oh my God, my exams are approaching and I don't know anything. So not to worry, it is there somewhere in the back of your mind. You just need to brush it up. So revise. First of all, revise thoroughly the IBC or the CIRP process that you have studied. Then only you will be able to compare it with PPIRP. Okay. So I hope you have got this particular idea of PPIRP so far. Now, one more thing. The meaning of pre-pack. Why do we call it as pre-packaged or pre-packed? Because the plan is already, I told you, we first of all discuss with the creditors, we first of all prepare a plan. We have a plan ready and we believe this can be executed, this can be approved and like things. So we have a plan ready, and on the basis of this particular plan which we have pre-packed, then we are submitting an application. Okay, so that's why it is called as pre-packaged, and it is certainly an informal arrangement between the promoters and creditors. As I explained you, it is informal as well as formal, I would say. And now we will start with the process. Okay, so let's now start with the process. But before we start with the process, once again, let's quickly recall, what do you mean by pre-packaged insolvency resolution process? It is an informal arrangement between the creditors and the promoters or the management, because what they do is they have a plan already ready. They have a base resolution plan. Okay, BRP. There are in fact certain definitions which have been introduced under section 5. Section 5 2A is BRP. The definitions, although do not tell us the exact meaning, but they have been incorporated for the sake of law. So BRP is simply the resolution plan which is prepared by the corporate debtor, which is provided by the corporate debtor to its creditors, right? Then we also have an information memorandum. I'm just quickly reviewing the terms that we might be discussing over this process, although all the terms and definitions they are given, but as I told you, they do not have much relevance because they do not give a very exact or a concrete meaning to us. So we have certain definitions which have also been introduced through the amendment. The first one being base resolution plan, that is commonly known as BRP, base resolution plan. See, as I told you, in this whole process of PPIRP, what is happening is the creditors, the bank and the company is going to discuss everything, right? Informal discussions they have. In fact, the company, the MSME will prepare a base resolution plan. That is, they have some base. They have some base. This only goes out to prove that I have some backing, I have some base. On the basis of this, I'm proposing or I'm filing an application that yes, this corporate debtor, this company, this MSME can come out of that insolvency situation. So I have some base ready with me, and that base is even given to the creditor on the basis of which they approve. Okay, yes, we should go ahead with the filing of application and we must start this PPIRP process. Okay, so this is a kind of informal arrangement that happens, and that's why it is pre-packaged, and that is the definition of BRP. It is the plan which is provided by the company, which is provided by the corporate debtor to the creditors. You also have information memorandum. Now, what is information memorandum? Again, nothing is given in the definition. It only says information memorandum which is submitted by the corporate debtor. That is information memorandum. Okay, so these are the two terms which I wanted you to know before we can proceed further. And now let's have a look at the process. The very first requirement, just listen to it like a story. Okay, and if you understand the concepts, it won't sound boring, or it won't be like, oh, what is ma'am saying? Just, I hope you have understood the meaning of this whole process, and after that you just have to listen to it like a story, and we will discuss the whole process. So first of all, I'm going to brief you for the whole process, and then we'll discuss everything in detail one by one. Okay, so first requirement, whether I am MSME or not. So the first thing that I'm going to do is check the criteria of MSME and see whether I'm MSME or not, right? When do we need to check it? Of course, in the event of default. So if MSME has defaulted, that is, has not repaid the debts, is not in a position to repay the debt, there is a default. If the default is just of 2 lakhs, well, you don't have a choice. You don't have a choice. You cannot go for all this process. If the amount of default is 11 lakhs, you have a choice only of PPIRP. You don't have a choice of CIRP, because to go for CIRP, you need at least the default amount should be 1 crore. The minimum default amount should be 1 crore. So up to 1 crore, my dear, you only have the choice of PPIRP if you are MSME. But if the default amount is more than 1 crore, then you have a choice that you can either go for PPIRP or you can go for CIRP. Supposedly I am MSME. There is a default of 11 lakhs. I decide to go for PPIRP. What next? Only I can initiate, only the corporate debtor can initiate this PPIRP process. So despite the efforts that my financial creditor, the bank from whom I've taken loan, and I'm unable to repay that loan, that bank itself cannot go and file the application for PPIRP. So bank, if wants me to file that application, has to come to me. So there will anyways be informal arrangement. If I have to file an application, I need the approval of financial creditor. So I also have to go to him. So we anyways have to discuss. And this whole thing takes place in a period of around 90 days. Okay. Now, so if there is default, I am MSME, I comply with the amount of default and I want to go for PPIRP, then I need to check certain conditions. These are the conditions which must be fulfilled, only then I can make an application for PPIRP. And it is not that there is an or written between these conditions, that any of these conditions be fulfilled and I can make an application. No. I can make an application only when all these conditions are fulfilled. Only when all these conditions are fulfilled. Condition number 1. No PPIRP during 3 years preceding initiation date. No PPIRP preceding 3 years of initiation date. So when you are starting the PPIRP, before that, preceding 3 years, we need to check that there hasn't been a PPIRP process already with respect to that particular corporate debtor. Okay, so this is the condition. This is condition number 1. Not undergoing CIRP. I think by far it is clear that any corporate debtor, whether MSME, can go for CIRP also. So you cannot sail in 2 boats, right? If you're going for CIRP, then obviously you are already you're already in the process of insolvency resolution. Then why again PPIRP? There will be a huge conflict if you try to sail in 2 boats, right? You will automatically drown. So this is something which is not permitted. If you're already undergoing CIRP, you cannot make an application for PPIRP. Okay. No order of liquidation under section 33. If you remember, section number 33 of IBC was about initiation of liquidation. When we don't have a choice but to liquidate the corporate debtor, because there comes a situation when such corporate debtor's insolvency cannot be resolved, then the order of liquidation is passed and hence the liquidation is initiated. If supposedly I make a default of 2 crores, CIRP starts for me, and after that it comes, the authorities come to a conclusion that CIRP is not effective for me and they want to liquidate my company, and hence the order of liquidation of my company is passed. I get an idea. I say, okay, the CIRP didn't work for me, strike it off. I will go for PPIRP. I cannot, because order of liquidation has already been passed for me under section 33. Then declaration by director. What declaration do they give? PIRP within 90 days. Now what is this? You are creating so much of confusion. You just said that PPIRP has to take place within 120 days, and now you are saying that PPIRP has to be within 90 days. That is the declaration which directors will give. What is this nonsense, ma'am? See, I told you. I just now told you that there is an informal arrangement or agreement which is going on between the creditors as well as the corporate debt. This should be done within 90. Why? To assess the seriousness. See, when the directors are giving a declaration in writing that yes, we want to go for PPIRP, we have a base resolution plan ready with us, and we discussed the plan, we made the plan, we got the approvals, all this we have done in a span of just 90 days. That means we are competent enough to execute this PPIRP process, and we will be able to achieve the same in 120 days, because the management stays in the hands of the promoters and the directors only. So the directors give this declaration that yes, we are competent enough to do so, because we have achieved this I would say pre-initiation phase, or we have achieved this informal arrangement well within time, right? So in a time bound manner, we were able to come to this particular conclusion and get necessary approvals from the creditors and members likewise. So this was done within 90 days. This is the first declaration. We do not have any intention to defraud our creditors or likewise. And insolvency professional. We have, the directors do not propose the name of insolvency professional, nor they approve the name of insolvency professional. I repeat, just like CIRP, even in PPIRP, there has to be an insolvency resolution professional or insolvency professional who is going to undertake the whole process. And if you remember CIRP, in that also we used to propose, and whenever we proposed the name of IP, the authorities will check if there is any disciplinary proceeding pending against that IP, then he will not be appointed. Otherwise he will be appointed, right? Otherwise he will be appointed. That's how it is. Here also a name has to be proposed. While you're filing an application, you have to propose a name, but that name is not proposed by the corporate debtor. The name is proposed by the financial creditors who have 1/10 value, and it is approved by the financial creditors who have 66% value. So wherever approval is required, it's 66%. So that is how we get that is how the name of IP is proposed and the name of IP is approved. And the directors have to give a declaration that yes, it was done, it is done in such manner, right? So we have proposed and we have also got the approval of IP. So these are the declaration which the directors must give, post which the corporate debtor can file an application. Before that, the corporate debtor is not eligible to file an application. Okay. Then financial creditors who are unrelated, of course, have proposed IP and 66% have approved proposal, just what I explained to you. And eligible to submit a resolution plan under section 29A. Again, if you remember, under section 29A, we have discussed that who are the persons who are not eligible to submit a you can say be a resolution applicant, right? So are you eligible? If you are eligible, then only you can even go for PPIRP. If you're not eligible to be a to be an applicant under section 29A for CIRP, then here also you are not eligible. Now, one more thing. Since we have introduced this particular point, don't you think there will be an amendment in this section also, in the relevant section also? In every corresponding section where there was only CIRP written, there will be PPIRP also written. So there are so many amendments. When you look at the amendments, you will be like, oh my God. But then you need to understand that these are the amendments which are irrelevant, right? Which won't be asked ever in the examination. It is an obvious thing that at one particular point you are writing PPIRP. So wherever the reference is made of CIRP, then the reference also has to be made for PPIRP. There will be some provisions which are applicable to both PPIRP as well as CIRP. So that respective section, that respective chapters needs to be amended. But that amendment does not hold any relevance to us. It's not changing the provision. It's not actually amendment. Okay, it's like making necessary changes pursuant to this particular amendment. This is the amendment, this introduction of chapter 3A, the whole new process. Okay, and SR by members or 3/4 by partners, LLP. If it is LLP, then 3/4 partners have to approve this. And if it is a company, then a special resolution is needed. So this has to be approved before filing of application. So if MSME satisfies these conditions, then only it is eligible to pass to submit an application. Right. Now, before we move further, One thing, that who is going to or what is going to be the PPIRP cost, because of course if you understand the whole process, section 523C, PPIRP cost, if you understand the whole process, there will be a lot of expenses incurred. Just like we have CIRP cost, we also have PPIRP cost. Let's discuss that later on. Okay, we will discuss that later on, because I'll just make you read the definitions once, so that is going to help us. Okay, now as we move further, we have sections 54A to 54P, and this is 54A only, 54A2, in which you have the eligibility, Okay, see, this is something that we have just discussed, the conditions for making application. Corporate debtors eligible for pre-packaged insolvency resolution process, section 54A, that is the first section of chapter 3A. Application for initiating this may be made in respect of a corporate debtor who is classified as MSME according to MSME Act. This is clear. So this point tells us that it is applicable only for MSME. So then, conditions for making application. What are the conditions for making application? Not undergone PPIRP in a period of 3 years preceding the initiation date. Not undergoing CIRP. No order of liquidation. Under section 33. Eligible under section 29A. Proposal and approval of IP, that is insolvency professional, has already been obtained, and majority of the directors have made a declaration regarding what, that they have initiated within a definite time period of 90 days. Then it is not to defraud any person. The name has been approved according to clause E, that is according to this particular clause, right? So these are the points we have discussed in detail. I hope you have understood this, and the members have passed a resolution for initiating the same. Sure. Okay, now before we switch to section 54B, we have another point in section 54A, which is about approval from financial credit. Now, approval we have already got. The financial creditors only proposed the name of an IP. See, the unrelated financial creditors representing such number as may be specified. Such number means that they should have at least 10%. They should be holding at least 10% of the value of the total debt. Supposedly the company has a debt of rupees 1 lakh. Then at least 10,000 you should hold. If it's 10 lakh, then at least 1 lakh you should hold. Then only you are eligible to propose the name. You're just saying that, okay, he is someone who is eligible, he is someone out of that data bank which is maintained by IBBI. So out of that particular list of people, you have to select one person and you can propose that let he be appointed as IP. So for proposing also, the financial creditors have some eligibility criteria to fulfill. If they hold at least 10% value of the debt, then they can propose the name of insolvency professional. And all the financial creditors who are unrelated, who have at least 66% value of financial debt, they are going to approve the name of such IP. In case the company doesn't have financial creditors, then you go for operational creditor. Clear? Okay. The corporate debtor shall provide such financial creditors with the declaration, special resolution or resolution which has been passed, the base resolution plan, and other information and documents as may be specified. That means what is happening at first, or let me take you to the process. We take you to the chart. What is happening? There is a default by MSME. The company prepares a base resolution plan. It passes the special resolution or resolution. It obtains the members of approval. This happens actually after this. The financial creditors propose the name of IP. The financial creditors approve the name of IP, and after this the corporate debtor gives declaration, the approved resolution of members, the base resolution plan that they have discussed, and even this approval plus other information to the financial creditors, and then they approve the filing of PPIRP, and then the corporate debtor files the application with the adjudicating authority. So till here you see, it is all pre-initiation, I would say. It is all that informal things that is happening. It is all the informal things that are happening, informal arrangement that is going on, right? So, if I ask you, let's understand. If I ask you, do we need approval by members to file the application of PPIRP? Your answer should be yes. Do we need ordinary resolution or special resolution? Special resolution. Do we need approval by financial creditors to file the application of PPIRP? Yes, 66% approval. The creditors, unrelated ones, holding at least 66% in value. Okay, so that is the approval that we need. Apart from that, who proposes the name of IP to the corporate debtor? Financial creditors having 10%. Who approves the name of IP? Financial creditors with 66% value. Okay, so what is happening? The company, the corporate debtor is preparing a BRP. The corporate debtor seeks the permission of its members that are you ready for PPIRP? They approve the same, passing special resolution. It provides the information to the financial creditors. They propose the name of IP, they approve the name of IP, and after that the corporate debtor is going to assemble all the information with the necessary resolution and everything. They are going to approach the financial creditors once again and ask them, can we go for filing? That is the time when financial creditors approve that, okay, yes, we can go ahead for PPIRP, and then the corporate debtor files the application for PPIRP. Then the corporate debtor files the application for PPIRP. What is happening next? Corporate debtor is going to file the application, the declaration by directors, the special resolution or the 3/4 majority members resolution, approval of financial creditors, name and consent of approved IP, plus information, any other information, plus declaration of transaction. Now this declaration of transaction is about that avoidance transaction. Not much relevant, but still I'll discuss when the section comes. Okay, so corporate debtor giving all this information in the prescribed form is going to file the application for PPIRP process after obtaining the necessary approvals to adjudicating authority, that is to NCLT. NCLT or adjudicating authority within 14 days is either going to approve or going to reject. Whenever it rejects, it is going to give a notice to rectify the defect within 7 days. If the company rectifies the defect, it is going to admit the application. If it does not rectify the defect, it is going to reject the application. Now, this application does not mean that you have to now execute your base resolution plan. No, this is just that application that we want to undergo the process of PPIRP, and the adjudicating authority has approved the process or approved your PPIRP application, which means as on the date of approval, that becomes your date of commencement of PPIRP. As and when it is approved, that becomes the date of commencement of PPIRP, and on the same day adjudicating authority declares moratorium, appoints resolution professional, and causes public announcement of the PPIRP process. Who is going to be appointed as RP? The same person who is proposed by the company, unless some disciplinary proceedings are going against that particular professional. If there are some disciplinary proceedings going on, he will not be appointed. Otherwise, the same person is appointed as RP by adjudicating authority. You get my point? Now, duties of RP before initiation. Before initiation. That means the packaged insolvency resolution process has not been initiated, has not been started, has not been commenced. What is the commencement date? When the adjudicating authority admits the application. That is the initiation. That is the commencement. This is all pre-initiation phase, right? This is all pre-initiation phase. When the application is admitted, then starts the formal process. Before that, an informal process is going on, right? But the name of IP has been suggested by the financial creditors and also approved by the financial creditors way before the application is admitted. So what does that IP do in this particular phase, that is before initiation? What a resolution professional, what an insolvency professional has to do? What are his duties? That is given in section 54B. Let us have a look at the duties. First of all, IP is going to prepare a report that the base resolution plan which the corporate debtor has prepared, it conforms to the standards which have been specified. Okay. It is going to file the reports and other documents with the board as specified, perform duties as specified. Okay, so we do not have to read much about it. When does his duty ends? The corporate debtor fails to file an application for initiating PPIRP within the time period stated under declaration. If you have stated in the declaration that this process has taken only this much time period and it is going to be completed in this particular time period, that means from the day of passing resolution, from the day when you started these informal talks till the submission of application, the time should not be more than 90 days. If you have already taken 110 days, that means now you have exceeded the time limit. So obviously the IP who was appointed to work as an IP, now his duty is no more relevant, right? The application for initiating PPIRP is admitted or rejected. See, if it is admitted, then his duty for the pre-initiation phase ends, and now he will, if he is appointed as RP, he will now have different duties. If the application is rejected, he will have no duties at all. Okay, so when an IP is proposed and approved by the financial creditors in the pre-initiation phase, what he does is file some documents as specified, discharge duties as specified, and prepares a report about the base resolution plan. Okay. Now, the fees that we are going to pay to this IP, because we have already appointed him, is going to be the part of PPIRP cost. If you know that we have CIRP cost also. So when we approve a plan for insolvency resolution, then we also need to take care of the CIRP cost. In the same manner, when we approve the plan for PPIRP, we also need to take care of PPIRP cost. That out of that, in that plan, this cost should also be met. So paying fees to IP is also the part of PPIRP cost. Okay. So now we move to the next section, section 54C. Section 54C. I have incorporated all the sections at once in this chart. Okay. So if you don't want to go section by section and just know the provisions or revise the provisions, this chart is going to help you tremendously. Okay. Now, this application process is given in section 54. What is it? That corporate applicant, because only he can file the application, in the manner prescribed. What are going to be the attachments? The declaration, special resolution, approval of financial creditors, name and written consent of IP, declaration about the transactions. See, I told you avoidance of transactions of fraudulent or wrongful trading. Then information related to the books of accounts, that is, I have written over here info. Now, adjudicating authority within 14 days will either admit if the application is complete. If it is not complete, it will reject, but it will give an opportunity to rectify the defect within 7 days, and thereafter it's going to accept the application. The date of commencement, very important. The date of commencement from the admission of application. So from the date when the application is admitted by adjudicating authority under section 54C, that is going to be the date of commencement of PPIRP. That is going to be the date of commencement of PPIRP. Okay. Now, next section, section 54D. Section 54D. Time limit for completion of pre-packaged insolvency resolution process. The whole process has to be completed within 120 days from commencement date. That means the period of 90 days is not included in this 120 days. See, within 90 days, you have to complete this informal arrangement, and you have to file this application of initiating PPIRP with the adjudicating authority. After this is the date of commencement date of PPIRP. This is the date of commencement of PPIRP. From here, my dear, you have a time period of 120 days to complete PPIRP. This is the date when adjudicating authority has accepted your decision of PPIRP. Now you need to work on your decision. You need to decide what are we going to do, how we are going to do. You have to prepare a committee of creditors. You have to you have to improvise your plans and like things. And finally, you will get a plan approved by your committee of creditors, and then you will submit a plan to adjudicating authority, and adjudicating authority is going to approve the plan. This whole process has to be done within 120 days. Within 120 days. Okay. So resolution professional shall submit the resolution plan as approved by committee of creditors to adjudicating authority within a period of 90 days from the pre-packaged insolvency commencement date. And when no resolution is approved by committee of creditors within the period of time, the resolution professional shall, on the expiry of such time period, file an application for termination of PPIRP. Now, what is it trying to tell us? See, we have this 90 days, which is the pre-initiation period. Pre-initiation period, or you can say the time of informal arrangement plus filing of application. Okay, now on this date you have filed the application and it is approved by the adjudicating authority. That means this we can call as the commencement date. Now from here to here you have a period of 120 days, but again this particular period is divided into two parts. One is 90 days, and the other is 30 days. Till here, that means within the span of 90 days you have to file approved plan with adjudicating authority. If no plan approved, then file application for termination. That means end this, because there is no plan which can be approved by the committee of creditors. Now this next 30 days is for adjudicating authority to approve the plan. Mark my words here, my dear. This commencement date is when adjudicating authority approves your application. It is approving the application for undergoing the process of PPIRP, and that is the time when PPIRP process starts. So a resolution professional is appointed. There is a whole moratorium period wherein you cannot enter into a lot of things, transactions, and there is a public announcement that this particular company is going through the process of PPIRP. Resolution professional collects from the company the list of claims that okay, the company has to make payment to these many people. Based on that claims, it forms a committee of creditors. That committee of creditors, they meet, they discuss, they are provided with the plan, the base resolution plan which the company has already made. And then we also have a concept called a Swiss challenge. We'll study a little later. So the committee of creditors are being provided with the base resolution plan. They discuss the plan. They finally approve the plan. And when that plan is approved, the resolution professional takes that approved plan and goes to adjudicating authority to file that approved plan. This has to be done, this whole process has to be done within 90 days. If you are unable to get any approved plan, then you file the application for termination of the whole process, because the time has expired. The time limit has expired. Okay, now once you have filed this approved plan, adjudicating authority also needs the time to study the plan, to think and decide that okay, this plan is not doing any harm to the operational creditors, to this person, to that person, etc., etc. Right? So once adjudicating authority also understands the plan and approves the plan, that will be the end date of PPIRP. So the whole process of PPIRP has to be done within 120 days. Some students have this misconception that PPIRP end date is when all this is executed. No, my dear, the day plan is approved, that means the things have been settled. Now this execution, this is an ongoing process. Slightly, slowly the things will change, right? So this has to be done within 120 days. That is what the time limit defines. Hope this is clear. So we have section 54D, which tells us about the time, limit. Okay, we move forward. So PPIRP has been commenced, and PPIRP has to be completed within 120 days. 120 days is divided into two parts. You can write over here 90 days plus 30 days. 90 days is for the resolution professional to submit the approved plan, and 30 days is for adjudicating authority to approve the plan, approve the submitted plan. Okay, now section number 54E, simple moratorium and public announcement, which we know in CIRP, so I'm not going to repeat the same. Sorry, so I'm not going to repeat the same. Okay. So adjudicating authority on commencement date along with the order of admission, they are going to declare a moratorium, appoint resolution professional as named in the application if no disciplinary proceeding is pending against him, or based on the recommendation of board if there is any disciplinary proceeding which is pending against the person. Board means IBBI. Now, cause a public announcement if the initiation to be made in such form and manner as may be specified immediately after the appointment. So all these things I've already told you. Adjudicating authority is going to declare moratorium, appoint RP, and cause public announcement. Okay, the moratorium is going to be for this whole process. That is going to be the moratorium period. Okay. Then we have section 54F, which talks about the duties and powers of RP during PPIRP. That means after PPIRP has been initiated, after the commencement date, what is the duty of RP, what they have to do. We will read this a little later because I want you not to break the flow of the process. Okay, so we will do it at the end. Next comes section 54G, list of claims and preliminary information memorandum. So once this commencement of PPIRP has taken place, within 2 days, corporate debtor is going to submit the claims. They have a list of claims which is ready with them, that they have to pay money to such and such person, right? Supposedly the corporate debtor has to make a payment of 10 lakhs to this creditor, 4 lakhs to that creditor, 7 lakhs to this creditor. So they will prepare a list of claims. They have to provide this list to resolution professional, because now he becomes the in charge. He has to do all that, assemble all the claims, to collect all the claims, work on them, constitute the committee of creditors. He has to even call the meetings, etc., etc. So corporate debtor is going to provide the list of claims, information, as well as the base resolution plan. All these three things are being provided to RP. You might be of the view that, ma'am, resolution plan he already had because he also prepared a report. Well, maybe, quite possible the resolution professional has been changed. Earlier there was another IP, now some other RP has been appointed, right? So that is why this is being written. If you already have, the company will not provide it. Okay. So within 2 days, a list of claims, preliminary information memorandum which contains the information. That's it. It is not defined anywhere properly. Okay. So this is provided to resolution professional. Now, sometimes it happens that the directors or the promoters or any partner, they intentionally or they do not provide, or they change the list of claims. There are 5 creditors, they skipped 1 creditor. They said, no, this particular person is not going to let us do our work in a flow. this creditor, if he attends the meeting of committee of creditors, he is going to definitely bring in some obstacle, because he never cooperates, and we don't want to pay him anything now, we don't have any good business relations with him, etc., etc. So they skipped the name of one creditor. Who is going to be liable for this? Because resolution professional is going to work on that list of claims which he has got from the company, and the company has not provided the name of one creditor. Who is going to be liable for that? So we also have a liability for incorrect information. Now such creditor might have sustained some loss because he was not included, his name was not included in that list. So in such case, every person who is a promoter or a director or a partner, at the time of submission of list of claims or the information memorandum that you're providing, or if you're someone who has authorized this submission, shall be liable to pay compensation to every person who has sustained loss of damage. If you had given your name, if you had not skipped someone's name, the company would have paid to that person, but now you are going to be personally liable for payment, personally liable for the damage or for the loss or for the compensation. Okay. Now there is just one simple clarification, that if there is any person who has suffered such loss, they can move to a court for seeking compensation for the same. If the list of claims was submitted by the corporate debtor without his knowledge or consent, supposedly I am the director but I was out of town for that 1 month and I have not seen the list, I have not given my consent of the list, then I can escape this liability. I will not be liable. So this is a kind of defense which any person can bring in, that I was not aware. Okay, so in that case he will not be liable. Simple section, section 54G. Okay. Now section 54H, kind of important, because you must know that in PPIRP the management is going to stay with the corporate debtor. The management is not going to be passed to the RP. This is the major difference between CIRP and PPIRP. The management of affairs of the corporate debtor shall continue to be in the hands of directors or partners. Both shall make every endeavor to protect the value of the property of the company. The promoters shall exercise and discharge their obligations in relation to the corporate debtor. So very generic and simple section. Now, committee of creditors. The application is admitted, moratorium is declared, RP is appointed, and public announcement has already been made. Within 2 days, corporate debtor has also given the claims and information to resolution professional. Now, resolution professional, he is appointed on the same day when it was admitted, when you can say when the application was admitted. So, within 7 days of this commencement, within 7 days of this commencement, he has to constitute a committee of creditors. Within 2 days, he'll get the list of claims, right? So, on the basis of that claim, he is going to constitute the committee of creditors. And once he has constituted the committee of creditors, that these are the persons who are going to be the part of the committee of creditors, then within 7 days, he has to also hold the first meeting. First meeting within 7 days of constitution of committee. Okay, so this is as and when the list gets updated, then you can also change or alter the committee of creditors. It's not like that once the committee of creditors has been constituted, it cannot be changed. Committee of creditors will obviously have the financial creditors. All the financial creditors, however, the ones who are related will not have any right of vote. And if there are no unrelated financial creditors, then the operational creditors. Clear? Right? Okay. Now, see, sometimes it happens that the company is unable to revive from the state of insolvency because the ones who are managing the company, they are involved in fraud. So despite all the efforts of the resolution plans, of the creditors, of the resolution professional, still the corporate debtor will not be able to revive from the state of insolvency because the ones who are managing the company, they are fraudulent people. And in PPIRP process, the RP cannot take over management. So how will the company revive? It becomes very difficult. It has advantages, but it also has disadvantages, right? So in such a situation, the committee of creditors have a power. What type of power do they have? They have the power that at any time during that PPIRP process, that means during that 120 days, they can, in any meeting, they can pass a resolution, they can resolve with 66% voting, and they can say that the management should be handed over to the RP. Now, only if they resolve this, only if they pass this resolution, the management will not be shifted to RP. What happens? Committee of creditors said that we do not want this management. We want RP to take over management. So they passed a resolution in that regard with 66% value votes. RP will now file an application to adjudicating authority. In that application, RP is going to say that committee of creditors have passed this particular resolution, and adjudicating authority, if thinks that yes, the affairs are conducted in a fraudulent manner or there is gross mismanagement means something which is huge, okay, then it is going to pass an order for vesting of management with the resolution professional. So it's not like that in PPIRP process it is mandatory that the management is going to stay with the corporate debtor. If there is a case of fraud, as I told you in the beginning itself, if there is a case of fraud, then the committee of creditors can resolve that the management be shifted to RP. Okay. Now this non-applicability, the provisions of section 14, section 17, 18, 19, 20, 25, 28, some provisions, they are also going to apply. See, as long as the management was with the corporate debtor, there were no provisions. Okay. Now, when the corporate debtor is going to shift the management to RP, then the relevant sections, the relevant points are also going to be applicable. So this is just about applicability in which you don't have to do anything. Now comes our important concept called as Swiss challenge. Swiss challenge is popular in a lot of countries and known as known by different names. Now, in fact, PPIRP that we are talking about, pre-pack plan, etc., it is a popular concept in a lot of countries. Now, what is happening thereafter? I think you have understood the process so far. First meeting within 7 days of constitution, and then resolution professional presents the base resolution plan to CEOC in 90 days from the commencement date. No, actually, you remove this over here. Okay. This is something which is going to confuse you. Okay. Second, my dear. I think now this seems better. So resolution professional is going to present the BRP to COC to committee of creditors. Fine. COC is going to approve or reject the BRP by 66% voting. Now listen to me very carefully. You are going to understand an altogether new concept called as Swiss challenge. What do we mean by that? See, what is happening? There is a base resolution plan. What is base resolution plan? Which is just going to consist of a plan that how are we going to resolve the state of insolvency. That means maybe we are going to install 2 more machineries, we are going to increase our production by 20%, we are going to do this overtime, how are we going to change our operations, we can take the help, this particular financial help, and this is going to help us, this way we can invest, this way we can earn, whatever things you have decided, that is a plan that you have made, and this particular plan was ready before initiation of PPIRP. So you have a plan already ready. So after the application is admitted, RP is appointed, RP constitutes the committee of creditors, then is the time when you present, when RP presents before the committee of creditors that this is the plan which we have for you. You study this plan, you analyze this plan and tell me whether you approve this plan or not. Because once you approve this plan, then only we can go to the adjudicating authority and ask for their approval. So you must approve this plan first of all. Now, committee of creditors might think, oh, it's a super plan, excellent plan, we approve it immediately. So the plan by 66% votes is approved. But there might also be the instance or case when the plan is rejected. Here comes in picture the concept of Swiss challenge. That means now we are going to invite the plans to challenge our BRP. So resolution professional is going to invite the plans. That if anyone has a resolution plan, be the resolution plan applicant and submit the plan. You need the information about the list of claims and like things, you take that information and you give me the plan. Yes, your plan should conform to the guidelines that we have given you, to the standards or to section number 30. Section 30 has some basis for every plan. So it should conform to section number 30. It should conform to the guidelines that we have given to you and give us a plan. Take the information that you need from us, but give us a plan. So there will be different applicants who are going to give the plan to resolution professional. Resolution professional is going to study each and every plan, see which plans conform to the guidelines and reject the other ones. Out of that eligible plans, present the plans in front of committee of creditors. Okay. Now, best alternate plan is selected. If there are 5 eligible plans, you select the best alternate plan. We already have a base resolution plan. Okay, it's like a competition. You already have one competitor ready and you have to select the other competitor. How do you select the other competitor? In layers. First of all, you invited so many competitors, then you saw that these are disqualified ones, these are not eligible ones, so you eliminate them in the first round, then some come to the second round, and out of that second round you select the best one. That person is going to be sent to compete with this BRP. So we select one best plan from the alternate eligible plans. Right. So that best alternate plan is sent to compete with BRP. BAP is sent to compete with BRP. Now they are going to compete with each other. Who do you think should win? Of course, ma'am, the one which is better. BRP can be improvised. BRP can also be improvised. You can change BRP, right? So the best plan out of the two is going to be selected by the committee of creditors, and they can approve this alternate plan also. They can approve that resolution plan also with, of course, changes, no changes, whatever the situation be, right? So what is happening is RP invites plans under Swiss challenge. Committee of creditors is going to complete the process of improvement in BRP and select one resolution plan which is significantly better out of the from the best alternate plan and the base resolution plan. Okay, I have written some general lines over here. I hope you have understood what I'm trying to tell you. Then within 90 days, COC is going to approve base resolution plan or the other plan. Okay, that is best alternate plan. Is either going to approve the BIP or the BAP. If it approves the same, resolution professional shall file the improved plan to adjudicating authority, and now adjudicating authority takes the time span of 30 days. So within 30 days, adjudicating authority is either going to approve the plan or reject the plan. If it approves the plan, PPIRP is completed. Now, if committee of creditors got the plan but still they did not like any of the plan, they were not satisfied with the plan, they did not approve any plan, then RP is going to file an application for termination of the process of PPIRP. Okay. Clear? Now, let's have a look in detail at the section 54K. Presentation of BRP. Corporate debtor shall submit the base resolution plan to RP within 2 days of the commencement date, and RP is going to present it to the committee of creditors within 14 days of PPIRP commencement date. Okay, I have actually removed the date. If you want, you can write the same. Now, committee of creditors is going to provide an opportunity that as and when required, you can improve your BRP also. Okay. Of course, before the approval or before invitation, you can revise it. No problem. Fine. The resolution plans and BRP should conform to section number 30, as I told you. Committee of creditors can approve the BRP if it does not impair the claims of at least operational creditors. That means it is at least, the plan is at least able to provide that if a company has an operational debt of 2 lakhs, then it should be able to pay at least that operational debt. Okay, so impair means if I have to pay you 2 lakh rupees and out of that plan, however, no matter how hard I'm trying, I'm able to pay you only 50,000. That means I'm impairing, right? This is called as impairment. If I'm able to pay full 2 lakh to you, that means there is no impairment, at least to the operational creditors. So you can do that impairment to in case of financial creditors, but not in case of operational creditors. So if there is no impairment, the committee of creditors is going to straight away approve the BRP. But if the committee of creditors does not approve or there is impairment, then what is going to happen? Resolution professionals shall invite the prospective resolution applicants to submit a plan to compete with BRP. Resolution applicants, the plan that they submit must fulfill the criteria which has been specified by the committee of creditors. I told you that. Resolution professionals shall provide to the applicants that how your plan is going to be evaluated, that is the criteria, the other information that you might need. So on the basis of that, they are going to submit the plans. The resolution professionals shall submit the plans which are eligible. That means out of the plans which have been received by RP, it is going to check that which are the plans who conform to these standards of section 30. Only those plans will be presented in front of committee of creditors, and out of those plans which are presented, they are going to select the best alternate plan. Now that best alternate plan is going to compete with BRP. So there are two chances. One, that the best alternate plan is better than BRP, or if the selected plan is not better than BRP. So if the selected plan is better than BRP, the committee of creditors decides that yes, it is significantly better than the base resolution plan, so they will approve that plan. Okay, and if it is not better than PRP, then they are going to decide. Then what is going to happen is not considered for approval or does not fulfill the requirements of subsection 10, it shall compete with BRP in such manner and subject to such conditions, and one of them shall be selected for approval under subsection 12. So there will be a process of comparison, process of competition, right? And then one plan is going to be selected. Out of this, one plan can be approved, and the approved plan will be submitted to adjudicating authority. Where the resolution plan is not approved by the committee of creditors, then RP has to file an application for terminating the PPIRP process. And the approval has to be by 66%, considering the feasibility, viability, everything, the priority, the order of payment, the interest, security, everything. So after considering all the factors, committee of creditors can approve a plan. They have to approve with the 66% of voting at least. And whatever plan they approve, that is going to be submitted to adjudicating authority. Now, dilution of promoters' shareholding. This is a point often students don't understand. See, whenever you are considering the feasibility of any plan, you have to see that what is the impairment. What is the impairment? Impairment to operational creditors is not acceptable, but there can be impairment in the debt of financial creditors also. What do you mean by that? Let's simplify it. Say for example, I have taken a loan of 20 lakhs from a bank, and now I am not in a state to repay the same. I undergo this process of PPIRP, and in the plan that comes out to be the best one, I am able to repay to that financial creditor an amount of only 15 lakhs. That means somehow that financial creditor will have a loss of 5 lakhs. Right? He is that particular financial creditor is going to suffer a loss of 5 lakhs. But what about the promoters, the shareholders? What about the promoters, the shareholders? This point tells us that in such a situation, the promoters also must dilute their shareholding. The promoters who have incorporated the company, they have, if I have 500 shares in a company, I'm sitting stagnantly. Okay, no problem, I will still have 500 shares. In future, maybe the company resolves, the share prices go high, I will make huge profits. Why? If that financial creditor, his debt, his right is getting impaired, then you also must lose something. So you must also dilute some shareholding. You must also let go of say 200 shares. So now you will have only 300 shares. That means company's liability towards you will also reduce. That is known as dilution. Dilution of promoters' shareholding. And why is it important? You must have understood by now, right? So such plan should also talk about dilution. If it does not provide for such dilution, then the committee of creditors, prior to their approval, they shall record the reasons that why are you approving such a plan in which you are suffering from impairment. You will not be getting your full debt, but you're not providing for the promoter's shareholding dilution. So what is the reason that you're approving such a plan? Okay. The resolution plan, a professional shall submit the plan as approved, and this is not at all important. It is only mere clarification that corporate debtor is the resolution applicant. It may submit the plan either jointly or with any other person. Then the claim shall be considered to be impaired if it does not provide for full payment of the confirmed claims. And this is something that you already know. This is just an explanation which is being provided to you. Right. Now, within 30 days of receipt of the plan, AA is going to approve the plan. Right? And before approval, AA is going to satisfy itself that yes, it will be effectively implemented also, because effective implementation is more important. Just on paper approval does not mean everything and anything, right? If AA is not satisfied with the plan, what then? Within 30 days, it is not satisfied with the plan, it can reject the plan. It can reject the plan. But what next? If the plan is rejected, what is going to happen? Well, where the adjudicating authority has passed an order under section 54J, and the resolution plan approved by committee of creditors, as the case may be, does not result in the change of management of control of the corporate debtor to a person who was a promoter, etc., etc., the adjudicating authority shall pass an order rejecting the resolution plan, terminating PPIRP process, and passing a liquidation order and declaring that PPIRP cost shall be part of now liquidation cost. Shall be now the part of liquidation cost. I don't think I need to explain you anything in this. Right? If you just want to recall, you can write over here also. Section 54J, what was it about? It was the change of management. Change of management. See, overriding anything contrary contained in this section, whenever adjudicating authority has passed the shift of management, okay, and the resolution plan approved by COC does not result in the change of management, okay, of the corporate debtor to a person who was not a promoter or in the management, then the adjudicating authority shall pass an order like this. What is the reason for the same? What do you think is the reason for the same, for passing such an order by adjudicating authority? See, if we look at this particular point, we need to understand this, you can say, is a case of bound rejection. This is a case of bound rejection. Our section 54L actually talks about approval and rejection. Either adjudicating authority is going to approve the plan or reject the plan. When it rejects the plan, it passes an order under section 54N. Okay, that we will see the rejection part. But in this case, what is happening is, the committee of creditors made an allegation on the management of the company that such management is involved in fraud, and made an application under section 54J, pursuant to which adjudicating authority passed an order of change of management. And now you are coming up with a plan which involves the same management. That means there is some mismanagement already.
right? Because if the management, if the directors were engaged in fraudulent activities or gross mismanagement, then again the same situation of the company will come. So what will be the point of PPIRP? You have to resolve the state of insolvency. You don't have to again push the company, push the corporate debtor, push the MSME into the same pothole of insolvency, right? You have to revive the company from there. And for that, change of management is essential, which was already established under section 54J. So this particular section tells us that if adjudicating authority has passed an order of change of management and the committee of creditors have approved a plan which does not change the management or control, then adjudicating authority is bound to reject the resolution plan because it does not make any sense. So in such case, adjudicating authority will reject the resolution plan, which it will pass the order of liquidation and also declare that whatever cost has been so far incurred in this process of PPIRP, that cost will now be a part of liquidation. Clear? So 54L tells us that whenever plan is being filed with adjudicating authority, it can either be approved, it can either be rejected. But if this is the situation, then this order of liquidation plus rejection will be passed, because in such case the company cannot even go on. It cannot even continue with the state of insolvency, because it is very clear, it is evident that there is fraudulent management or gross mismanagement. So it's better that the company be liquidated and this process be terminated. Okay. Now section 54M, just that you can appeal against this order of section 54L on the grounds as laid in section 61, right? So that is a separate thing. Then comes 54. When the plan is submitted by resolution professional to the adjudicating authority can either approve the plan. If it approves, then that marks the termination, that marks the completion of PPIRP process. But if it is rejected, then what is adjudicating authority going to do? Adjudicating authority within 30 days of application terminate PPIRP. See, termination of PPIRP can also happen pursuant to section number 54K. If you remember, when we were discussing the process of PPIRP, there was a base resolution plan, then there were other plans. We selected the best alternative plan. Then out of the BAP and BRP, we selected which is significantly better, but still there can be a situation that committee of creditors did not approve any plan within the span of 90 days. So within 90 days, no application with the approved plan could be submitted to adjudicating authority. So resolution professional at that particular point of time had to file an application with adjudicating authority for termination of PPIRP process. So that is section 54K. Okay, so that is section 54K, and or under subsection 3 of section 54D. Okay, we also have to discuss about the duties. I don't think I have discussed the duties with you. It will not take much time. Section 54D tells us about the time limit. It tells us about the time limit. Supposedly the time limit has expired and the corporate debtor resolution professional, they could not do anything. So automatically it will be terminated. Okay. So in this case also, when the adjudicating authority rejects the application, it is going to pass an order under section 54N, and even in under the two cases that we have already read, 54K and 54D, in these cases also PPIRP will be terminated, because either the committee of creditors could not approve any plan or the time limit has expired. Section 54K and section 54D. So in both these cases, adjudicating authority is going to terminate the PPIRP process. So it will pass the order of termination and the process will end right there, and it will also provide the manner of continuation of proceedings initiated for avoidance of transactions, that how these proceedings will be continued. See, what do we mean by this avoidance of transactions under chapter 3? Let's say, for example, let's say one type of transaction, undervalued transactions. There are certain transactions which needs to be avoided. Now, when this process is going on, there might be some transactions which have been undervalued intentionally so as to do any fraud or any activity like that. And if resolution professional comes across any such transaction, it is going to make an application to adjudicating authority, and adjudicating authority reverses the transaction. That is, it is going to be nullified. Fine. So we don't have to read all that in so much detail. But then this order will also provide how those proceedings will be treated on. Apart from that, at any point after the start of PPIRP process and before approval of plan by adjudicating authority, that is the completion date, right? So during that period, if COC wants, if COC, that is Committee of Creditors, if they want, they can terminate PPIRP process. If they want, they can terminate PPIRP process by 66% voting. That means even if PPIRP has been started with the consent of financial creditors and all that, but during that process they realize that no, I'm not so willing or this is not working out as it should be, they have two options. The Committee of Creditors can terminate PPIRP, or they can also convert it to CIRP if eligible. This is section 54O. We'll read it. Okay. Now, if PPIRP started and it is terminated, PPIRP started, resolution professional was appointed, there were so many costs which were incurred, and now PPIRP terminated. So who will bear the cost? The corporate debtor will bear the cost. Okay, this can be asked as an objective question in examination. Now, adjudicating authority has passed an order of change of management, or it is required, or termination of PPIRP, then adjudicating authority shall also pass the order of liquidation and declare that PPIRP shall be included as the part of liquidation. Okay. This again simply means that it is very clear to the adjudicating authority that corporate debtor is in wrong hands. It was mismanaged, it had fraudulent people, and now we thought that okay, PPIRP will come up, there will be change of management, there will be a beautiful resolution plan which will help the company to revive. But unfortunately, this PPIRP has to terminate. It cannot continue. So PPIRP was not successful, it could not be completed, and it was terminated for whatsoever reason. Adjudicating authority realized that there is fraud involved and PPIRP was not successful. This is a deadly combination, and the only solution to it is liquidate the company, because we cannot let go of the company that okay, the company will go on. The company cannot go on, right? Okay. So I hope this is clear. Now we come to section 54O. The Committee of Creditors at any time after pre-packaged insolvency commencement date but before the approval of resolution plan, by a vote of 66%, they can also resolve to initiate CIRP. If at any particular point of time they feel and they realize that no, PPIRP is not working, then they can resolve, they can, by passing a resolution, come to a conclusion that we want to shift to CIRP. In such a situation, resolution professional will go to the adjudicating authority and tell to adjudicating authority that COC has taken this decision. Adjudicating authority within 30 days will pass the order of termination of PPIRP and appoint resolution professional to carry out CIRP. So he will become the interim resolution professional. He will become the interim resolution professional. Now, first thing, supposedly, the default amount was 12 lakhs only, and the corporate debtor went to PPIRP. Now the creditors resolved that we do not want PPIRP, we want to shift to CIRP. We want to shift to CIRP. Can we? Well, CIRP is never an option available for you, right? But if the default amount is 2 crore, and PPIRP was going on, now the creditors, by passing 66% votes, they want to resolve that we want to shift to CIRP. Can they? Yes, they can. Again, what happens? When PPIRP process commenced, there was a resolution professional who was appointed with his due consent and everything. He was appointed. He thought that this whole process will only take 120 days. There will be no change of management. This is easy. I will be easily able to do it, devote that particular time, etc., etc. Now, this has been shifted to CIRP by virtue of section 54O. What will happen now? This RP might not be ready to be appointed as interim resolution professional and thereafter resolution professional as it happens in the process of CIRP, because this is more time consuming, this is involves more time, effort, everything. So we need to obtain his consent over here also. So submission, subject to submission of written consent. If he does not provide his written consent, then adjudicating authority will appoint someone else based on the recommendation of board. Board means IPPI. Okay, clear? So now, so far, the cost must have been incurred. Supposedly 2 lakh rupees has already been incurred. Now this will be now the part of CIRP cost, and whatever resolution comes up, it also has to take care of this cost also. Okay, so CIRP cost will include that PPIRP cost also. Sure. Now see, wherever adjudicating authority is passing this order of conversion to CIRP, it will be treated as if the application under section 7 has been made. When application is made by the financial creditor under section 7, that is the time when CIRP initiates, right? So it will be treated as that particular point only, and CIRP shall commence from the date of such order. The proceedings shall continue during CIRP. Insolvency commencement date for these sections shall mean this also, and not relevant. Now, apart from this, we also have the last section, that is section 54P, which only contains some applicability as in we have part 2. And part 2 talks about corporate insolvency, which has different chapters, right? We are reading chapter 3A, which is a newly incorporated chapter. We also have chapter 2, we have chapter 3, then we have chapter 6, chapter 7, right? So they are also going to be applicable to PPIRP. So we have certain applicability things, some interpretation part, right? So this section 54P is something which, after reading the whole PPIRP, you will be able to understand it like in seconds. Okay, so it does not have anything much. Okay, and we had left a section, right? We had left the powers and duties of resolution professional during PPIRP. So let's have a quick review of the same. It is going to conduct the whole process, undoubtedly. It is going to confirm the list of claims. Whatever claims, list of claims, resolution professional receives the list of claims within 2 days, right? So within 2 days it has received that list of claims. It is going to confirm that the list of claims is correct or not. Third party confirmations for the creditors. It is going to inform the creditors that this is the list that I have received, and it is also going to maintain an updated list. There might be some creditors who will turn up to the resolution professional and add their claims. Some might delete their claims. Hardly anyone deletes their claims, but there can be these updations. So he has to continuously update the same, has to also monitor the management of affairs of corporate debtor, inform the committee of creditors if there is any breach by the directors. In such a manner, they also get to know what we have read in section 54J. It is going to constitute the committee of creditors, convene its meeting, prepare the information memorandum, which is on the basis of preliminary information memorandum. See, PIM is prepared by the corporate debtor, and based on that you also have to provide the information memorandum, which is going to be relevant for all the resolution applicants. When resolution professional invites the applications from resolution applicants, it also needs to provide them adequate information that on this basis your plan will be evaluated. So you must conform to these guidelines, and this is the information that is required by you to prepare a plan. So this is the information that we are going to provide. That is that also has to be prepared by RP only. File applications for avoidance of transactions. So this is the application which I already told you, right? There might be some transactions, undervalued transactions, preferential transactions and like things which must not take place. And if RP notices such transactions, it files an application with AA to reverse the transactions, right? So those proceedings are already going on, which is also the duty of RP, and such are the duties as may be specified. Then it also has powers. What powers? It will get access to all accounts, records, information, electronic records, books and accounts which are available with the government authorities. It will attend all the meetings of members, directors, partners, whatever the case be. It can also appoint some professionals if it needs help. Supposedly I'm not well equipped, or I'm not very well versed with some process which I must understand to evaluate the plans or anything like that, so I can hire a professional and take help of them. Collect all information relating to assets, finances, operations, etc., to check this transactions involved in wrongful trading or fraudulent trading or avoidance of transactions, etc. Okay, so we have more, and also collect the information relating to business operations of two previous financial years, and take other actions as may be specified. Now we have certain more things. What are these more things? Financial institutions maintaining accounts of corporate debtors shall furnish all information to RP. This is all about assistance. Financial institution will provide information. The employees, the promoters, or any other person who is connected with the management, they will extend all assistance. The fees of RP shall be determined and borne in the manner specified. The committee of creditors can impose certain limit on the fees or expenses. That's it. 54G I have already told you. So we are done with all the sections pertaining to this IBC new chapter 3A. I hope you all have understood the same. I don't think I have missed out on any point. Right. Okay. Thank you so much.